Good afternoon, everyone, and welcome to this afternoon's presentation on family and estates. My name is Jessica Steingart. I'm a staff lawyer here at the Center for Public Legal Education, or CPLEA for short. And there's a few other faces on your screen as well, which I'll get to some introductions in just a moment. So, what are we talking about today? We're talking about the crossover of family and estates law. So, sometimes we think of law in terms of these, different silos or different areas, family, criminal, estates, consumer, but there's lots of overlap, we know. Many issues can cross over different areas of law. And so today we're talking specifically about the overlap between family law issues and wills and estates issues. So we're going to be talking, we have 13 questions we're going to work through together, and then hopefully we'll have some time for some questions from the audience at the end as well. So the Center for Public Legal Education respectfully acknowledges that we are located across Treaty 4, 6, 7, 8, and 10 territories. And we respect the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continue to enrich our vibrant community today. Okay, today we're going to be talking about all things legal, but I have to just put out a quick disclaimer that we are talking today about legal information. So none of the information we share today is intended to be legal advice. I also want to give a quick shout out to our funders. So the Alberta Law Foundation, the Department of Justice Canada, and the Alberta Real Estate Foundation for providing funding that make webinars like this one possible. A few more housekeeping items. First, we are recording the webinar today, and it will be available to watch on demand at any time on our YouTube channel. And once that's done, we'll send out an email to everyone letting you know that it's available. As I already mentioned, we'll hopefully have some time for some questions at the end. So please submit them using the Q&A function. You can enter them at any time, but we will only be addressing them at the end of the presentation today. And finally, when you exit today's webinar, you'll be prompted to complete a short survey. We'd love for you to take 30 seconds, fill that out, let us know how we did today, and also if there's any other topics you're interested in learning about. Okay, so before we move on, a little bit about CPLEA. If you haven't heard of us before, who or what is CPLEA? So CPLEA is the Center for Public Legal Education Alberta, and our goal is quite simple, and that is to make the law understandable for Albertans. I should say our goal is simple, but sometimes executing that goal is not always so simple. So we are a nonprofit organization that serves all of Alberta. We provide legal information and education through our various booklets, tip sheets, videos, webinars, websites, and more. And our goal is to make not only the law available and understandable, but hopefully also empower Albertans to use it to resolve the legal issues or even prevent them in the first place. So this is our home page. So if you head to cplea.ca, you will find all of our resources in these different boxes. If you click on them, you'll be led down trails to take a look at all of them. As you can see, we cover a variety of legal topics, and we also have some resources available in French. As we go through today's presentation, and I see there's already a few popping up, we'll be posting some links to some of our resources in the chat. So you're welcome to take a look at those. We'll also send out any links that we post in that final email. We'll send those out. We'll send out the links in that email as well. Okay, so without further ado, let's get to our panelists and get right into our conversation. So our first panelist is Matthew Mowbray. So Matthew is a lawyer and mediator whose blend of knowledge, experience, and humor assist him in helping others navigate the transactional and spiritual challenges that are present when estate and family law intersect. And Matthew is with Woodbine Legal Services. So thank you, Matthew, for joining us this morning or this afternoon. And thanks. And our second panelist is Victoria Jones. So Victoria made DeVillers Jones LLP a two-generation firm when she joined her parents at the firm where she is now the managing partner. She primarily litigates estates with a side of estate planning and administrative law. She's appeared at all levels of court, including at the Supreme Court of Canada. She was part of the team that designed the surrogate digital service and continues to ensure that estates are administered in a common sense manner, even if that means suing a bank or two. Thanks, Victoria, for joining us.
You're welcome.
Okay, so like I said, we have 13 pretty dense questions that we're going to work through today. So let's get started with our first one. Does my spouse or partner automatically inherit everything if I die without a will? And I'm going to turn it over to you, Victoria, to get us started.
For sure. Classic lawyer answer, it depends primarily on the children. If there are children of the deceased that are all together with the one partner or spouse, then yes, that partner or spouse will get everything. If there are children from a previous relationship, then the estate is going to be divided. The partner or spouse will get either one half or $300,000, whichever is greater. So generally these days when people die, if they own a house, their estate is going to be greater than the $300,000 mark. And so the partner or spouse may not get everything from your estate.
Matthew, do you want to add on to that?
Oh, the other thing I always think is interesting is sometimes family law can take a while. And so it's also possible for a new adult independent partner or a new partner to also inherit when someone passes away as well, which can make it even more complicated.
Yes, people can die with both a spouse and a common law partner. Those are the best.
So, like I said, these questions are going to be dense and heavy hitting today. So, okay, so it depends. And I love that. Okay, let's move on to our second question. What happens to joint property or property that I own jointly with my spouse or partner when one of us dies? And Victoria, I'll start with you again.
Sure. So the law is that if you own property jointly with a spouse, it goes automatically to that surviving spouse, and it is not in your estate. This is not true if you jointly own property with children. Just to warn everyone, trying to get around probate on your matrimonial home and by putting your kid on title is going to cause me to get a lot of your money in litigation. So don't do it.
I think
I
something
love
else that kind of comes up with that too is if you're separating and this is a concern or there's health issues, uh, you can always make an application to sever that joint tenancy through the Law of Property Act, and that's kind of a way to kind of deal with that, especially if you had concerns about this.
Yeah, I feel like I'm going to talk more about if you die in a happy relationship, and Matt's going to talk about if it was an unhappy relationship, because there are different aspects to that, and the law does give you avenues to sort it out based on the quality of the relationship on death. And so I feel like based on our last two questions, I'll be the happy one and he'll be the unhappy one.
Big sad face.
Yeah.
Sorry.
I love this. We have the opposing sides already coming out. This is great. Okay, so joint like we said, joint tenancy, usually the right of survivorship, but again, it depends. There can be situations when that doesn't happen. Matt, you look like you were gonna
Well,
jump in
you
with
can
something
have, like,
else.
for example, I mean, you can be tenants in common. Tenants in common just means that you each own your portion of
Hmm.
that property as well. So you could have a 50% and 50% ownership, and you see this more with investment property, associate more with like siblings, but I can see it with, partners as well, particularly from an estate planning perspective. If it's a second relationship, they might do tenants in common. So that's just another estate tool where it's not joint tenants so that each of them will know, hi, I get half of this property, I get half of this property, and it goes to their estate, and then their estate would, whatever their will says, would deal with that. So, a little bit rare, but again, something that I deal with in relation to planning.
So that could be something done on the front end when you're actually buying the property. It's at that point that you decide if you're buying it with someone else, are we going to be tenants in common or joint tenants? And so that can be a tool to look at that time. And if you're not sure if you own it as joint tenants or tenants in common, then look at your certificate of title that you would have gotten when the real estate transaction closed. Do they still print them on pink paper when they send them to you? No? Okay. Uh,
No, and they're not that extra
the long
foolscap
ones?
sheet. No,
Yeah.
they're just regular paper now.
So when you get that from your when the lawyer who helped you with the transaction transaction, let's send that to you. And it'll actually say underneath your names whether you're tenants in common or joint tenant. So if you're not sure, then that's a quick way to double check for yourself.
And if you are doing estate planning and you don't know how your property is registered, have that estate planning lawyer pull the title because
Mhm.
it might change the discussion of
Mhm.
how you're going to do things, particularly as Matt said, in a blended second or third marriage or
Mhm.
relationship.
Okay, let's move on to our next question. Very important question. Who will take care of my child if I die? And
I
I will
think this
start
should
with
be
Matthew.
Matt. Yeah, I was like,
Yeah.
So when you talk about, I mean, the first question you have is, do you have another parent who's involved in that child's life? So if you're married or you're in a common law relationship and you're living together, well, then the other parent is going to be that person who's going to automatically take over. Um, Similarly, if you have a parenting order with someone else under the Family Law Act, the person who have that parenting order, that second parent will take over your rights nominally as well. Now, there's some reasons why people are like, oh, well, I don't want that. I don't like the other parent, particularly after they separate. And so there's a couple of things to keep in mind. One, if you have a will, you can name a guardian under that will. That does kind of give a little bit of ability to do that depending on the other parent's involvement in the child's life. Uh, and then if you don't have a will, typically a couple of things will happen. One is uh, who is the child living with? So if a death is sudden, uh, the public guardianship trusteeship office might step in and kind of help facilitate that. If there's close family involved, they might be there. But if you're naming a guardian under a will, even just taking a step back, a couple of things that you have to keep in mind is one, you can't foist your children onto other people. They have to actually accept that guardianship. So something to keep in mind there. And then in looking at that as well, I think that again, if you don't have a will, that there's ways around this too, such as someone can apply if they just have the child for 6 months. You can go into even more detail, like uh, if there is no guardian, so say there's a car accident, sadly, and both parents pass away, if the child's over 12, they actually have to consent to that guardianship as well. So it kind of gets into a lot of different details under the Family Law Act, what would happen. But the kind of default rules would be one goes to the other parent, two, it would go to if there's no other parent or guardian, then whatever is named under the will, so long as they accept that. And then three, they would try and find the closest family member through the public guardianship office. And again, if the child's over 12, they'd have to consent to that new guardian.
Victoria?
some things to consider if you are doing a will and you're going to appoint a guardian is can that guardian use the estate money, which we're going to assume is going to the child, but can they use it to do things like get a house that that child can live in? Get a car that can fit everyone. We had a file where young children, like under 5, were suddenly their uncles now, and he and his wife led quite a nice child-free life, and they didn't have a car that had more than 2 seats in it. So the question was, were they allowed to use estate money, which was the children's money, to buy a car so, they could actually drive the children around? Um, so those are sort of the things you need to think about. If you put it in your will, the public guardian and trustee has a much harder time fighting you on that. So consider that this is a thing for a person to take on, especially if it's not the child's other parent and that they may not have the funds, but the child hopefully will through your estate. So do consider that and that the guardians can have the benefit and keep that benefit once the child is out of their care. So you need to just have some thought to that in the event you're going to have children and you're doing estate planning. Um, a lot of people get held up completing their estate plan because they're not quite sure who they would want to appoint as a guardian. Just pick someone because it's necessary. You have a minor child, someone needs to be in charge of them. And if it's the other parent, that's great. But if it's not, you need to indicate somehow that this is a person who you trust to raise your child.
I think you'd rather, I mean, that's the big thing too when you talk about estate planning is if you don't choose someone, then you don't have any say, right? And who that person would be. And so, especially if you know what your child's wishes are, or who they're close to, that's a great way of putting in there so they're around there. Something else to keep in mind too is when picking a guardian is I've dealt with families with large, several children. They may have 4 or 5 children, and they'll name the oldest child as the guardian, and that oldest child is 19 in university trying to take care of 4 other children and deal with all the grief of their parents passing and that sort of thing as well. And so sometimes to think about is, who this person is will they have the ability to take care of them if it happens in the next few years? And you can always amend it. You can always redo your will and add a different guardian when they're a little bit older. But certainly had issues with young siblings who are adults and who are legally able to be a guardian, but perhaps have so many other things in their lives that they probably shouldn't be.
Okay, so two things I'm taking from this conversation. One, it's so important to make a will. This is our
Yes.
first pitch on making a will.
Yeah.
Second thing, these are not easy conversations. I mean, I have a kid, and these are not easy conversations. Think about who do I want to raise my child if I'm not here. Obviously, we don't want to be thinking about that. But I think it is one of like the best things that you can do for your family is to think about that and be prepared so that, if it does happen, you're not it can cause a lot of family strife then if different people are fighting over who is the best guardian. Whereas if you've made a will and you've laid out a guardian, then it's you expressing that and saying, you know what, this is who I think, and talk to the other people. I know I've had
Mhm.
conversations with my sisters who also have kids about, who is the best guardian for each of our kids. And if it's not someone who thinks that they should be guardian, even having that conversation about why you didn't choose them,
Mhm.
and just being really upfront about it while you still have the ability to have those conversations. So,
And having the conversation pre-death is so important because then your people have heard it from you. Uh,
mhm.
and they can sort of think about, oh, how would this work? For example, I was my niece's guardian for the first bit when they were first born. And I don't know my brother's mother. And so I had very frank conversations with him about your child should obviously have a relationship with your grandmother. How are we going to make that happen? And so we had that workaround. And then I was very happy that my sister-in-law's sister became old enough and stable enough that she's now the guardian because she will do a much better job than I would ever have done. But because we had the open and frank conversation, I
Mhm,
knew what was expected of me and who I could rely on to make their wishes happen.
mhm.
Everyone's going to die. Leading cause of death is birth, 100% correlation. So you may as well have these conversations as hard and as prickly as they are. They're important to have.
I think sometimes you can even bring closer together because you're being honest in a relationship. But I agree. I was going to say there's two things that are certain in life: death and taxes. So, have the conversation. It's worth it to do it now. Okay, let's move on to our question number 4. How do I deal with estranged family in my will? And I'm going to start with you, Victoria.
So in Alberta, the testator, so the person who does the will, owes obligations only to those that are dependent on them. Your spouse or partner, your minor children, and your adult children unable to earn a livelihood due to a disability. If you have a child who is estranged from you, but they're perfectly capable of earning a livelihood, you do not have to include them in your will. However, I generally include a reason why I have excluded someone from an estate plan. And the reason for this is you can't stop someone from filing a claim against your estate. You also are now dead. So you can't give evidence about why you did what you did unless it's in your will. If I have a document that you have signed, I can give it to the court to say, this is their reasoning. And the court's going to look at that because in Alberta, the testator's discretion and preference is highly uh, relied upon. So if you're going to disinherit someone who would normally you society would think you should include, say why.
I think the other thing too is in creating a will where, there might be either a sibling or a child that might be estranged is use specific names.
Yes.
right? So say, instead of saying to all of my children, you could just say to, Jimmy, Polly, Georgie, and that could provide a little bit more clarity as well when you do decide to exclude someone, because then they are not a part of the group. In that same way, too, when you talk about estranged family, even like unknown family or family that you discover down the road, you kind of see that in movies sometimes. And again, by putting specific names, it closes that group.
Perfect. Thank you. So again, we're making a will and we're
Yes.
naming names in the will and giving our reasoning. Okay, love it. Okay, next question. Can I, in the same regard, and I know you'll dive into a little bit more, maybe, can I leave my spouse, partner, or children out of my will? Victoria?
Technically, yes. But again, if they're a minor child, an adult child unable to earn a livelihood due to a disability, or your spouse or partner, they have a right to make what's called a family maintenance and support claim. It used to be called dependence relief. And so it's a public policy that a testator is not allowed to not provide for his dependents. So in fact, it's one of the main sources of litigation in estates right now are family maintenance and support claims, um, particularly in blended families. This is so it's an interesting balance that you will need to do, hopefully in your estate plan, about why you're doing what you're doing. In an intestacy, so that's someone who dies without a will, often those come, uh, a family maintenance and support claim is made because, as I said earlier, if you're the spouse or partner, you're getting half or 300,000, you're not getting everything. And maybe, in fact, you should be, right? Like perhaps you're the second spouse, but you've been around for 40 years. You came in when the kids were little. You're as good as a full spouse, but you're only getting half. So you can do it, but it opens up your estate to litigation.
I think the other thing to keep in mind too is that for that is they also have the opportunity to make a family property claim as well. And so if you don't include them, they still have that opportunity to make that claim for, assumption of 50% of your property division. And courts will look at that as well. So, I mean, the question again is kind of why are you not including them and trying to come up with a rationale again in a blended family. Maybe that's a conversation you have with them as far as your estate planning. And you do something else that provides, like a life insurance policy or RSPs that can be transferred outside of the estate to account for some of those other dynamics that might exist.
Yes. And often people will do a prenup. While a prenup is a consideration for the courts, it does not actually ward off a family maintenance and support claim, or at least not yet. One day we'll get that case, but currently it's just a consideration.
Perfect. And you mentioned, Matthew, life insurance policies and RSPs, and we will talk a little bit about life insurance policies in another question, but that, yeah, you can name specific beneficiaries for those outside of your will. So that's like you said, a consideration as well. It's looking at everything that's being left, not just what we consider in the estate. Okay, next question. I know this is a hot topic. Do I have to share an inheritance that I received during my relationship if we separate? And I'll start with you, Matthew.
So it's one of those it depends answers that everyone loves to hear when they talk with lawyers. So the yes part. So the yes part is it depends on what you do with that property after you receive it, but before you separate. And the no part is if you keep that property fully separate and apart from your relationship, you have all the decision making over the property, then you don't. Now, why is this? So the Family Property Act says that spouses have to separate and they're assumed to be all the property they accumulate is 50% unless you fall under an exception under Section 7, or I call them like exemptions under Section 8. And so for property that's inherited, it's basically it's an exception. at the time that you inherit that property, the value of that property is going to be considered exempt. And so you don't have to divide that. However, under the Act, any increase in value in that property can then be considered joint property and it can be divided. And part of that, though, it depends. It can be divided unequally. And so it depends on what do you do with that property. If you go on vacation with it, well, then it's gone and you can't be traced into anything. You don't really have that. But if say you use it to buy a truck, then that property's joint. You both drive that truck. You take the kids, to sports with it. You go camping with it. Well, then it's going to be more and more considered joint property, and it's more and more going to be considered 50-50. If you buy shares in a company directly from that inheritance, and then you keep them completely separate, they're just in your name. You don't ask the other partner about them at all, how to do with them or deal with them. They're more likely to going to be more and more divided, as in you own all of them.
This comes down to some very old law called tracing. Can you trace the money or the if it's other property from you used it for? So let's say you get money and then you go and buy a house. Even if that house is put in joint names, you will be able to trace that money into the down payment. So you will be able to get that back out, that same amount. So, but that's one of the only ways you can keep your inheritance separate when you've actually bought something with it jointly with your partner. But if you just deposit that check into your joint bank account, it's gone. It now just forms part of the joint matrimonial or family property, and you've lost any exception or exemption to it. So as Matt said, it's really important what you do with that inheritance when you receive it.
Yes, open up a separate bank account in your name alone, put your inheritance in that bank account, and then decide what you'd like to do with it. And if that's a joint thing you do as a family, then that's great. There's no wrong answer.
Yeah.
But at least then that gives you the ability to make that decision and plan that a little bit more.
And of course, we're not heading into these relationships thinking everything's going to be doom and gloom, but but it can be that may be some relationships. But even in the most
Or
loving,
it's just smart.
it's just I was going to say, even in the most loving relationships, sometimes it's good to just put that away and then figure out what you want to do with it. So yeah, so I love that. It depends. And that is
I love it's a ounce of prevention is better than a pound of cure.
yeah.
You go into colloquialisms.
Yeah.
Hey, I think we have somewhat related, about someone, a pair dying. What happens to child or spousal or partner support obligations if the payor dies? And I'll start with you, Matthew.
So first, when someone dies, it ends, right? So they no longer exist. They cannot pay anything. But kind of what Victoria was saying before, you do get these maintenance and support requests based off of several factors, but really did the estate provide for the maintenance of the dependent individuals? And if that is the case, then it goes through again several factors like the duration of the relationship and what their health and age and other things like that that are again in the Wills and Succession Act.
Now, it also depends on, particularly for spousal and partner support, what the agreement is. Because oftentimes it won't necessarily survive the death, but there will be an agreement that maybe there's an insurance policy that's irrevocable, so you cannot change who the beneficiary is. It's going to go to the former spouse or the child as a way to provide for them. Um, in the event that there is a spousal support agreement that survives death, but you don't do something like an insurance policy, if there's nothing in the estate when the person dies, you're not getting anything as the former spouse. So be aware that some of what you need to deal with is post-death because one of you is eventually going to die. Um, and particularly you want to make sure the kids are cared for. And one of the leading factors in a family maintenance and support claim is what does society expect? So if the two parents are highly educated and they have kids, it will be expected that those children will go to post-secondary education, and the estate's going to need to contribute to that. So when pre-death and during a divorce or a separation, you need to think about what might happen if death occurs. And there are various ways to ensure that someone is provided for in death that doesn't lead to a court application.
So one of those is, as Victoria said, you can do an insurance policy that has an irrevocable beneficiary, and is kind of a guarantee for support, for child support or spousal or partial support. And oftentimes you'll see that in agreement that this can be changed when the child turns 18, as an example, so that it covers for that. Another thing to keep in mind too, when you're talking about what is the value of the estate, is that child support has a preference over spousal support. So they're going to make sure that the kids are taken care of first. And if there's sufficient funds left, maybe spousal support. And then you obviously maybe everything else as well.
Perfect. Thank you both for that. So again, lots of planning. It's a good idea to do this, lots of planning beforehand. Okay. Does my separation or divorce affect my will? I'm going to start with you, Matthew.
So yes, it can. So one of those, again, it depends answers that we love as lawyers. So there's kind of different stages. So the first one that I always say is in Alberta, if you do not have a will and you're intestate, it's 2 years is kind of the limitation period. And that kind of coincides with the same limitation that you would have had to file a application or anything else from the date of separation moving forward. The next thing is if you do have a will, but you aren't divorced yet, then no. And so that's one reason why you might want to change your will. And I deal with that quite often. And nothing's worse. You have this high conflict family law case, and they've been fighting for like 6 years. And then one of them passes away, but they haven't changed their will, and they're naming their former spouse, who they haven't divorced yet, as their executor and primary beneficiary. And that then sets off a whole new set of litigation regarding the estate, and how that should function. However, if you are divorced, divorce will remove someone as a uh, beneficiary executor under your will. The other thing too is if you have a separation agreement, then it becomes to how it's drafted. But the separation agreement itself can affect whether or not you can be a beneficiary under a life insurance policy, because you can waive those rights under a separation agreement. Whether or not you can be a beneficiary under a will, because you can waive those under a separation agreement. So that's something to make sure that you kind of read in there or include in there, as well, if that's important to you.
Yeah. And so let's say you've started the family law process of separation or divorce. You can do a will, and what you'll need to put in it is in contemplation of my divorce or of my ending of the relationship, I do X, Y, and Z. If you have a will that appoints your now former partner or spouse and gives them a gift, and then you divorce, the Wills and Succession Act kills off that appointment and that gift. But the problem is, and this is happening more and more, people aren't actually getting the final decree in divorce. So, as we said earlier, it's entirely possible to die with a spouse and an adult interdependent partner. And that is an absolute mess to sort out because they both have similar claims. And so you need to figure out what's going on. And they probably don't enjoy each other, is the other concern. But yeah, if you are in the divorcing process or the separating process, do a new will, please. I had one where they mediated and settled their divorce on Friday. He died Saturday. Did he change his will? No, no. So all of a sudden, they had spent gobs of money on lawyers for her to get everything in the end. So do a new will. It doesn't hurt to do it, and you can, in contemplation of my divorce, of this relationship ending, this is what I want to happen. Um, while technically your partner would have a claim to make, again, the family maintenance and support claim exists for them if they are still married. Uh, it will be a factor that, oh no, you were in the middle of a divorce, and how close had you been to actually getting divorced? The courts will take that into account.
I want to put on the happy face part of this now because there are couples who separate and their relationship isn't over just because they separate. They're able to co-parent their kids, they're able to be positive. And in that same thing, if you did want to provide something specifically to your spouse post-divorce, you can, and you can say, notwithstanding my separation agreement, notwithstanding my divorce, I would like this to go to that person. So something to
Yes.
bear in mind there as well.
And you need to be very clear about that because the act assumes you don't.
Yes.
So just if you in fact do, make it very, this is your way to tell the court, this is actually what I wanted. So make it really easy for them.
Perfect. So again, change your will. That's the message I'm taking away from this. Change your will. And if you do want to leave something for them afterwards, make sure it's really clear because like Victoria and Matthew said, otherwise the court will assume you didn't want to leave something to your ex-partner, ex-spouse or ex-partner. I want to say CPLEA has some resources on like, things to think about as you're making a will and what that looks like. And one of the things we always stress is if there's anything in your relationship that changes, it's a good time to revisit your will to see if it actually reflects your wishes going forward. So, big life events like children or marriage and divorce, children, marriage, divorce, separation are all good reasons to revisit your will. Okay. We've talked about this a little bit already, but we'll see if there's anything more to add. Can my former partner or spouse make a claim against my estate? And I'll start with you, Victoria.
They can if it's been 2 years or less from either the divorce decree or the separation. Um, but they are limited in what claims they can make. It's really just to ensure that the family property division was appropriate at the time it was made. It is not uncommon that during a divorcing procedure, certain assets aren't disclosed, but on death, all of a sudden they are. So it's really just an opportunity to ensure that what the former partner or spouse should have gotten is in fact correct, but it is a limited claim that they can make.
And I've seen that particularly when they've provided their kids as their beneficiaries, and then kids, provide the copy of the will to the mom or dad, who then notice, hey, well, this was there. I thought we owned this together, such and such many years ago, and so it's interesting when those sort of things happen.
Yes, and it is also a weird thing when the children are the beneficiaries, their parent, their other parent, is making a claim, but the one, whomever the executor is, because they're actually the ones defending the claim, decide to fight it. But the kids are like, no, it's fine. Give mom, mom can have it. That's okay. So if you're that executor, just be aware that you are responsible to the beneficiaries. And if you decide to take a path that the beneficiaries don't agree with, you could be on the hook to them. So just be aware.
I always like saying too, if you ever find yourself in the role of an executor and you have no idea because you're facing some of these complicated questions we're talking about, the easiest thing to do is just go to court and ask a judge. Be like, hi, I
Yes.
have no idea what to do. Can you tell me?
And the application is literally called advice and direction. Give me your advice, judge, and tell me what to do.
Thanks for mentioning that about executors or personal representatives. Again, we CPLEA has a resource on some of the roles and responsibilities of that because it is a huge role and it's a massive role to take on, and especially in family situations or the family dynamics is a little bit volatile. So yeah, thanks for mentioning that about going to court. There are, I guess the takeaway too is that there's help available. So don't think you can get a lawyer as well. You can go talk to a lawyer for the estate
Yeah.
as well. So
And technically, executors that are not lawyers are required to have a lawyer to appear in court because
exactly.
so you're kind of stuck in a weird way. But
So you do have to get a lawyer.
yeah, unfortunately, if you're going to court as an executor or personal representative, you have to have a lawyer. So, but the
Uh,
estate generally will be paying for that.
I
Generally,
was
not
I
always.
was I was gonna say it's not always your money that's on the line. It can be the estate as well. So, okay, let's move on to our next question. We talked a little bit about life insurance policies already, but does my divorce affect my life insurance policy? And Matthew, I'm gonna turn it over to you.
So first, if your life insurance policy has a cash value, then it becomes property that can be divisible as part of your divorce. The other thing to keep in mind is that if you're divorced and you have a joint life insurance policy, one of the things that you should probably do is looking at separating that into two separate policies because that'll make your life easier down the road. Then lastly, the life insurance policy itself say when someone passes away, the answer is no, it's a contract with the insurance company. And so, for example, say you have a designated beneficiary on that insurance policy, and that is your spouse or your former spouse or your three times former spouse, which I've dealt with before,
Mhm.
they can still have a claim against that policy, barring some other reason why not. One of the reasons why not can be in your separation agreement, you put in a waiver of any benefits towards life insurance. But otherwise, no, they would be entitled to it. And that could be something you buy a life insurance policy because someone miraculously comes to your door, you get an email that you respond to and you pay it and you forget about it. And so again, deal with those when dealing with estates. 20 years ago, someone bought a life insurance policy and paid the full premium.
Yeah. If you're going to do estate planning, one of the questions I ask is of the various financial instruments that can have a designated beneficiary, do you know who it is? And are you happy with that? Because one of the fallouts of estate planning often is people go and make sure they've got who they want as their beneficiary. You can also do a designation in your will that will trump what's out there. Um, but that beneficiary needs to get to the life insurance company before the previous beneficiary does, because the life insurance policy holder, like the life insurance company, won't know. So again, it's one of those, make sure your paperwork's all good. Do a will. An ounce of prevention is worth a pound of cure. And it is impossibly hard to claw back life insurance that has been paid out to a beneficiary inappropriately.
And the other thing is you don't have to change the benefit of life insurance policies or anything with a designated beneficiary is you don't actually have to change your will. It's
Yes.
simply a piece of paperwork with the agent for that company to change your beneficiary. So sometimes if you're like, oh, I need to change this, and you keep putting it off and putting it off, like just get it done, like make it a priority in your life, and you'll avoid certainly hassles for your executor down the road.
Yeah. And actually sign the damn piece of paper and send it in. It's one thing to sign it, but if the life insurance company doesn't have that signed paper, they don't know. It's not, to them, it doesn't exist.
Perfect. Thank you. Yeah, this is an area where, again, planning is so, 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 so important. And making sure you know what is out there. Knowing, if you're like me and you bought a life insurance policy, and I was much younger and you're thinking, yeah, okay, yeah. And you just name a beneficiary because, your parents, because that's what you wanted at that time. And now as you're getting married again, revisiting and going, is that still, I mean, I'm sure my parents wouldn't say no to it, but is that still who you want to be the beneficiary of that policy? So it should be some, if you're working with a plan with a financial advisor, hopefully they're also cueing you to look at that. But if not, then it's a good idea to keep those papers together and make sure you look at them every once in a while.
I mean, even on the policies too, just to add, you can have multiple designated beneficiaries by
Hmm.
percentages. Most
Hmm.
policies allow you to have, if this person isn't available, you can have a secondary beneficiary
Hmm.
built into that policy, almost like you would do for a will as well.
Yeah.
So you can put those things in at the very beginning instead of like, oh, I'm just going to put one name down.
Hmm.
Yeah. And if you're designating a minor as your beneficiary, you can also designate who their trustee should be.
Hmm.
So pick someone who won't fritter away that money.
Hmm. And then you can change it, like we've said later on.
Absolutely.
So let's do it at the beginning, but then you can change it later on as well. So, okay. Next question. What happens if someone dies before their divorce is final? We've had remnants of this throughout the conversation already, but Matthew, I'll turn it over to you to talk about the highlights.
Yeah, so one thing to keep in mind is when we look at like both family legislation and estate legislation, they're provincially enacted. So the legislation in British Columbia, Alberta, Saskatchewan, Ontario are all going to be slightly different. And so one of the things that, if you look, okay, if they die post separation, but after, or sorry, post separation, but before they actually have their divorce finalized, what happens if they move jurisdiction? So they move to BC. So what can happen in that circumstance if they've decided, and it's kind of where they want to be domiciled is the legal word, but really it just means is where do they decide to live? And if they decide to live in that jurisdiction, well, then that jurisdiction can have the prescribing, say, estate uh, legislation that would then need to be applied. And so that can make things more complicated, which is why make a new will. If you decide to, after you separate and you decide to move, make a new will in your new jurisdiction, so you kind of know what's happening there because there are differences. The other thing too to keep in mind is if someone passes away, and we've kind of touched upon this before, but before the divorce is finalized, the divorce is what severs that executor beneficiary from that former spouse. And so if you haven't changed your will, they can still inherit everything. I think Victoria gave a good example of that one.
Yeah. Yeah, this is again, ounce of prevention, pound of cure. If you have started the dissolution of your family, go and do a new will. The where people get so caught up and where it causes so much friction is if there's no will whatsoever. And then the lawyers, have to sort out what's going on and who's getting what, who's entitled to what, and competing claims. So I think the theme of today is it does not hurt to go and get a will done, especially if you are dissolving the family.
Perfect. And I think we have a question in a minute here that addresses like if you in tangentially if you die without a will, I mean the law says who's going to get everything. And so, but you may not want to leave it up to you don't want to leave it up to those folks. So
Yeah.
planning ahead's important. Okay, let's move on to this question. What should I know about estate planning with a blended family? Victoria?
So know that while you're alive, everyone might get along, but that's going to end as soon as you die. Um, because you don't actually know the dynamics. And there's different types of blended families. The most common is children from a first marriage, and now there's a second marriage, but there aren't children from that second marriage. That's actually the easiest because generally you need to provide for your spouse. But if they've come in later in life, maybe they have their own assets, maybe you've done a prenuptial agreement and you've sort of sorted that out, but you need to provide for your spouse. But at the same time, you want to make sure each of your children um, gets a piece of your estate. When it gets harder is when there are now children of the new marriage. And how are we doing all of that? So it's harder when all of the children are minors. Once you have adult children and they're off on their way, you'll have a better understanding of what's going on with them, with what they might need. Um, and that will be a little bit easier. But honestly, it will come down to expectation and how have you treated your children, both your biological children, your stepchildren, your now shared children, whichever, in life? Because frankly, it's very common for parents to be helping their children, a down payment, post-secondary education, all of that stuff. And not everyone gets treated equally. And so you need to be aware of perhaps that causing problems in your estate. But fundamentally, it's a question of who are you required to provide for? Your spouse and your minor children primarily. And then how are you going to sort it out? And there is various ways to do that, um, especially if there's a home. Let's say one partner brought the home into the relationship, and really that was built with their children's other parents and things. But you need to provide a living space for your current spouse. You can do what's called a life estate. Essentially, your surviving spouse gets to live in your house, but when they go, that house goes to your kids. So there's some frankly complicated estate planning that can be done. And again, go see a lawyer. Everyone should be able to do it. But at the end of the day, it's a question of who must you provide for? And then are there weird little landmines that you can adequately move around to make it easier when you're gone?
The thing I like saying too when you're talking about estate planning with blended families is because it can get very complicated, is that there is no right way. It's kind of the way that you want that works best for you in your situation. So when you talk to other people and they say, oh, this is what we did or this is what we did, don't take that as gospel. Like think of it like what can I do or what's the best thing for me and us as a family as well. And when people talk about, oh, I'm going to buy a new restaurant and they say location, 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 I always think when I deal with these family law estate blended issues, I'm always communication, communication, communication. So you can create joint wills together with your new partner, and you can have separate beneficiaries um, and separate executors and different things like that. But if you're communicating with each other and you know this is what our plan is together, um, that way you're having kind of just like dealing with children after you separate, you're having kind of a common message that's going to them so they know what they would be getting. They kind of helps their expectations. And by doing that, I think you help reduce potential conflicts after you pass away.
I think communication is a common, like, I mean, regardless of a blended family or not, just communication. People just want to know what's going on. I mean, within reason, what's going on. Not that you have to share everything with them if you're making a will, but yeah, communication, especially with your partner. Okay, our last question, and then we'll get to the few questions that are in the chat. So, do my stepchildren inherit anything if I die without a will? And I'll start with you, Victoria.
They do not. The only children that are entitled to inherit are blood children or adopted children. There is a slight movement afoot that stepchildren, especially if you have become their step parent when they're quite young, that perhaps they should have a claim on your estate, but currently the law is that they are not included as they are not the traditional inheritors of your bounty. But of course, if you have a will, you can include a stepchild. No problem.
Yeah, so when they're not included, the only way I've seen it is like you have been like their primary parent. It goes to when you talk about descendants within the Wills and Succession Act, it doesn't include stepchildren. So the only way of kind of doing that for stepchildren to inherit something would be more through a maintenance aspect, through like child support, as in they were acting as a parent, but not so in respect to property. And obviously, when they're a minor as well, when they're adults, then zero.
Yeah.
Perfect. Okay. Well, we've covered 13 intense questions. And I have a couple questions in the chat here that we'll get to. So the first question, do you need to leave money to the guardian of your children if you pass away? How do you ensure that they have money to care for the children? We kind of talked about that, but does one of you want to address that further?
Sure. So, um, generally, I'm going to assume that if you and your spouse are both dead, the children are going to get your estate. So it's the children's money. And you're just giving the ability for your executor, who is the trustee of the children's money usually, the ability to reimburse the guardians for things that they have done for the children. So it's not that you're leaving money to the guardian, it's that you're indicating to the person in charge of the estate, the guardian gets to be paid back for what they did. And hopefully you have constructed your estate plan in such a way that it's quite easy for the children to have their needs met. Like, let's say someone's really into sports and you build into your will that if my children have inherited my estate, before they get the money outright, my executor can pay for their sports camp. My executor can pay for their education, that sort of thing. So you don't need to leave money to the guardian specifically. It might be that the guardian is also your executor and your trustee, so it's all in one person. Frankly, I would suggest that, but it's not to the guardian specifically. It's for the benefit of the child, and it might be the guardian receiving that money to provide the benefit.
So there may be situations that, if the child is quite young, for example, and their parents pass away, that by the time the child turns 18, there may be very little money at that point left because it's been used over the course of their life or their childhood to provide for them. And so when they turn 18 or whatever the will stipulates is the age when they get, whatever's left in that trust, then they'll get paid out whatever's left. And it may be, who knows how much it might be, or there may be none left,
Yep.
depending on the needs. Okay, perfect. Okay, the last question. If mom and dad have been helping someone without a disability, so a child, do they have to continue that support post-death?
Legally, no, but it doesn't stop that child from bringing the family maintenance and support claim. There is some case law where what I will call the failure to launch child. It's not that they don't have the ability to work, it's that they just aren't using their ability. And there was recently a case where the child actually had a law degree and just refused to earn a living. And the judge said, no, you do not get more of your parents' estate just because you refuse to use your gifts to actually earn a living. And there's also, it's a question of what is the standard of living that a child needs. It's a different test than a spouse. Um, but frankly, in Alberta, if you are a child able to earn a living, regardless of how much that living is, you are not going to be successful. So no, you don't need to provide for them. You might wish to provide in your estate plan that perhaps the house isn't going to be sold right away. It's going to take 6 months. So the child that's maybe living in your basement has a bit of lead time to get their stuff together and move out. But no, you don't have to.
I think one of those challenges when you talk about this too, and I was just mentioning is dependent adults or children who are uh, maybe they have Asperger's and they're able to work, but they're not fully able to take care of themselves. And so that's, so if that's a situation where might affect you, it's really important to look at your estate planning as well and say, hey, like what additional support might they need, even if they have capacity, but they just need those additional supports and build that into your estate planning as well.
You also do not have to treat your children equally in
Yes.
your estate plan. So in the case that Matt just said, you might give a little bit extra to that child. So there's no requirement to be fair.
And what is fair these days? We always say in our house, fair is not always equal. So, um, okay, well, that is the end of our questions. Thank you both so much. Is there any final thoughts you wanted to share before we sign off for today? Either
Uh,
of you?
so we've talked about going and doing an estate plan. I am primarily an estate litigator, so don't do that because that's how I earn my money. And I make a very good living on people not doing a good estate plan. So if you don't want to buy my next pair of shoes, go and get an estate plan. There are lots of good lawyers in this province who will do it and do it, you know, it'll cost you something, but trust me, it'll cost you much less than when I get involved at the post-death. So, an ounce of prevention is worth a pound of cure. But in the event you don't do it, I'll happily use your money to buy shoes.
I think the other thing too, and just putting so if you are a beneficiary and you're not getting an equal share, because things aren't fair, before you say, well, this isn't fair, maybe ask yourself why they decide to do that. Uh, Deal with farms quite often, and
Oh,
the child who stays on the farm gets more, and sometimes that's okay because they're the ones that took care of the parents. So, before you get upset about something, hey, why didn't I get this? Maybe ask yourself, what relationship did you have, and is it worth that continuing, essentially a store of shoes that you might be providing to the lawyer to fight over that.
I love it. So do your estate plan now, or your money will be growing Victoria's closet. Perfect. Well, thank you both so much for joining us and for sharing all of your wisdom, legal information, not legal advice with us. Um, and yeah, thank you so much, and thank you to everyone who signed on today. And have a great rest of your day.